Welcome to the Divorce Matters Podcast, where we teach you how to survive the family court system. We will give you no-nonsense, straightforward strategies for getting you an equitable outcome. We guarantee you won't hear this advice anywhere else. A reminder that we are not attorneys and this is not legal advice. However, we will help you more than any attorney ever will. And now, here's your hosts, Michael Alexander and Mark Fidelman.
Hello, everyone. Welcome to Divorced Matters. Joining me today, a very special guest, Richard Rindt, and he's going to talk about his disastrous case and his reunification with his daughter. I'm not going to reveal too much right now, but before we jump into things, Richard, would you mind give us a little bit of background about yourself and your case?
Sure, Mark. Thank you for this opportunity. I want to thank you and everyone involved over there at the podcast for giving me this opportunity. So thank you for that first and foremost. A little bit about my case. My divorce case started all the way back in March of 2013 when the decree was signed. All the matters leading up to that involved about a 3.5-year separation, where going back to as early as 2009, were first indications that my ex was starting to have second thoughts about our marriage. I found out about some infidelity. I came to find out that there was some things that she was keeping from me in terms of our finances, where she was using a lot of extraneous spending to try to cope and try to manage some of her issues that were more medically based. She was struggling with mental health issues and with physical issues like where she had to get prescription medications and so on. So it really started to go downhill in 2009. That culminated with her refusal to try to reconcile the marriage leading up to 2013 when we signed our divorce decree. At that time, we had to deal with a situation where we have 4 children that we were blessed with in our marriage, but they were then going to be the recipients of a whole lot of chaos from that point forward. At the time that we signed the decree, there were a lot of things that were way out of balance and completely inequitable in terms of the financial settlement, the joint parenting agreement. But frankly, at that point in time, by the time we got to signing the decree in 2013, I was in pretty bad shape emotionally, mentally. I was struggling mightily with a lot of anxiety and depression. And so while I was trying to deal with that, I was also trying to work my way through what we tried to do with the mediation. And the mediation just kind of fell flat from my perspective because I was suffering so badly from the depression that I kind of came into that catatonic. So a lot of the things that ended up in our decree and our joint parenting agreement were things that I otherwise, maybe in a better state of mind or a better state emotionally, I never would have agreed to. So got off on the wrong foot even from the start. Fast forward about 4 years later in the story, and what she had decided to do was during my non-custodial parenting visits with my 4 children, she decided that she was going to start keeping the oldest 2 away from me on my parenting, the parenting time that I had assigned by the court. Of course, for the non-custodial parent, that usually means like a Tuesday, Thursday, every other weekend, every other holiday, things like that. We had the typical custodial, non-custodial arrangement. But she decided to start keeping 2 of my oldest away. And what I did from that point was try to work it out amicably, tried to give her every opportunity to reverse course and give me back the other 2 oldest ones. That whole thing was basically precipitated by them disobeying me and not obeying my rules in my home. And so she, rather than support me with my disciplinary approach, which she had always done before, since the time that we started the joint parenting agreement, at this point she decided to change it up and do something completely unilaterally on her own. She just decided to make up her own rules. By the time I figured, well, I could take this to court and let a court settle this fairly, objectively, all that type of thing, what I didn't know was that was never going to happen by the time I got to court. And what she did was she filed before I did. And in getting the attorney that she was able to retain, she kind of colluded and plotted with that attorney to go through a process whereby I would lose not just the parenting time and the custody of those two older kids, but everything she did through the court, through the family court, was something that she had planned to take away all four of them. So that whole thing was basically accomplished by her going in and making false allegations of domestic violence, which, as you know, is all too common in family court when one ex-spouse wants to get the upper hand. And so she was first one in to file after I had threatened to file to get my older two back. She went ahead and filed. She coupled that with false allegations of domestic violence. She had a very shoddy case where she made just complete misstatements of fact and just completely fabricated things that a judge and a GAL eventually just bought hook, line, and sinker. And so by the time she did that, what I thought was going to be me coming into court to defend myself with all the evidence I had that exonerated myself, it came down to, I found out that instead in family court, the father, like me in my situation, is considered guilty until proven innocent. One problem, however, you never get the chance, like I didn't, in an ex parte hearing that my ex-wife was granted, you don't get that opportunity to prove that you are innocent. So you are guilty until proven guilty, and you're assumed and presumed guilty from that point forward, has been my experience. So unfortunately, I had the unfortunate experience of finding out that family court is never about the best interest of the children. It's never about honoring and holding up the constitutional rights that the non-custodial parent should have. It's never about bringing in the actual evidence and proof and material testimony that would exonerate you. Instead, it is all completely aimed at who's got the most money that we can get and how can we stoke enough conflict so that we can siphon and steal as much money from that non-custodial parent as possible. That was the experience that I had. So when she made the false allegations, got the emergency order protection, which is another common scheme and another common plot to get the kids away and to get the money, she got the emergency order protection. She threw down and perjured herself and got the false allegations. And then at the same time she did that, she piggybacked on a petition to modify child support. The key factor there is as soon as she filed the petition to modify child support, that allowed the judge to use her own discretion, as they often do. She used her own discretion to freeze all of my assets. That meant that I had no other option except to represent myself pro se or pro per. And that also meant that she had all of the cards and I had none of the cards, because every single financial asset that I had was completely frozen, including my 401k. So where I could have dipped in and gotten all of that, to represent myself with a viable attorney, I wasn't even given that opportunity. That was the beginning of the end of crippling and destroying me financially.
All right. A lot to unpack here. Jeez.
Mm-hmm.
So this story I've heard so many times, it's not been funny. So let's begin. I wrote some notes here. Let's begin in mediation. Why in mediation did you give up your custodial rights and not you became non-custodial? I know you weren't in a good frame of mind. You were depressed. I mean, it's normal when you're going through these things. But did you not have a support system in place?
The support system that I should have had in place, quite frankly, Mark, would have been my closest circle of influence, my closest friends. In fact, I had more of an extended family in my church. So this was a situation where a lot of church members and close friends of mine in my church were watching her do this to me right from the very beginning, where they even were aware that she was having the extramarital affair. And they knew things that I didn't even know that they could have reported to the judge or the GAL. I thought that with mediation, that was a better option because that meant we weren't both lawyering up with high-priced attorneys. this mediator who came in, even though he was an attorney, the price was the focus, because it was only $1,000 versus what was going to be thousands of dollars to each retain our own attorney and fight it out. She came to me and was still gaslighting me and still trying to sweet talk me at that point, saying, we can get this done without having to go, blow all kinds of money and go broke trying to fight each other in court. Let's just agree on a mediator and then go in and take care of the details. Well, like I said, the situation when I got into the mediation was that I wasn't even in a state of mind that I should have been there by myself trying to mediate. I should have still had some type of advocate or legal representation for me. I thought it was all going to be equal and equitable. I found out she was the one who went in and wrote all the specifics and worked with this mediator ahead of me. And I wasn't given the opportunity really in a reasonable time frame to even look at it closely enough and digest it all and say, wait a minute, I have a question here. Frankly, I was so depressed. I was in such a state that I actually couldn't even get out of bed at that point. So it was so painful for me to even just get in my car and go to an attorney's office to take care of this. It was like I just wanted to say, okay, fine, now can I get out of here? That's the frame of mind I was in.
Yeah, I mean, I think a lot of men can relate to that. Some women as well. We're not just about men. It just happens to women as well, but mostly men. Let's be honest. The stats prove that up. All right, so let me just chime in here on mediation. First of all, if you're in that state of mind, you should not be doing it alone. And it's all about hindsight. It's not about beating anybody up. It's just about helping people learn from Richard and my mistakes, right? So in mediation, do not be negotiating when you're in a depressed state of mind. Have somebody there that's been through the process, because I think there's a lot of people that haven't been through the process, don't know what could happen to you, don't know that if you give up your non-custodial, how hard it is to get it back. So that is something people should know. What state are you in, by the way?
This was all occurring in the state of Illinois. And so I was at that point, I was well on to my career. I was 16 years married and on a career track at a corporate entity that was giving me all kinds of opportunity, and I was earning six figures. So of course the money was very attractive from her side of the table.
Yeah, I mean, the first thing these attorneys do, and most of them are scumbags, is they look to see how much money you have, your wife has, are there any family members that have money, and then they begin their plotting. And the amount of money I've spent, I don't know how much you've spent, but it's outrageous. Before I finally said, you know what? I'm going to go pro per. I'm going to learn the system. I'm going to become an attorney because I want to remain a father. And that's exactly what I did. And I don't know what your story is there, Richard, but I assume it's something similar. You spent a ton of money, and now you're at a well, we'll find out in just a minute before we continue where you're at. But it's I think, going back to mediation, you should try to stay in mediation, but you got to do it with somebody that's been through the process, understands all the ramifications of the decisions that can be done in mediation. Because if you don't, and you end up in family court, that is a shit show. If you're a father, you're going to get screwed more than likely. As Richard alluded to, they start throwing silver bullets at you or false charges, you're presumed guilty. And then that's actually written into the code. The judge has to accept it as truth until it could be seen otherwise. And a lot of times it's he said, she said, and he's going to err here. The judge, he or she, is going to err on the side of caution and let her have it, which totally jacks you up your case for the rest of the time being. Let me ask you something. On the silver bullets, because of the impact it had on your visitation and all the rest of that stuff, why didn't you file a civil lawsuit against your ex?
Well, probably the first consideration, of course, always comes down to money, because at the time that she went in and filed, and then also filed for the modification of child support, she was actually tripling the amount that we had agreed to in the original decree. And so I was just scrambling just to try to find somebody to represent me just for the matters of how they were going to calculate modification of child support, because I was cognizant enough to know that when I was looking at with 4 children and a marriage of at that point 16 years, I was looking at a significant percentage of what I was going to lose as my gross, earnings, and giving that over. Not that I didn't want to support my kids, but I was scrambling just to find a way to get just a basic attorney to represent me for all of my interests in this case, because I didn't know where it was going to go from there. In hindsight, there's a lot of decisions I could and should have made, and even tried to sacrifice to maybe reach out and try to beg for more money, help from those. But I was already doing that. So, it was because it was disrupting my work. I was trying to give work my priority. And of course, once the court proceedings start in family court, you just get papered to death. You have constant distractions and constant answers you have to give to every next motion and every next petition. Her strategy and her plot the whole time was just to paper me to death, disrupt me at work, and then ultimately get me fired from my job because of the impact on my productivity. So to exacerbate that, what she also did, once she had taken away the 2 kids, then she shut off her phone and email. So I had zero communication and contact with her by phone, email, or text. If you can imagine 4 teenagers, 1 in 8th grade and 3 in high school, and imagine what their schedules look like with sports, social events, church activities, every other thing that goes on in a teenager's life. And their mother had shut off her phone where we had been cooperating up to that point. And now she shut it off. My phone lights up like a Christmas tree every afternoon at work at 3:30 when they get out of school. You can imagine all the changes in plans and all of the pleas that they have for, can I do this now? Can I do this now? And so on. So all of that complicated my situation, because not only was it affecting my personal time and my family time, but also now directly impacting my work. So I was fighting on all fronts, trying to keep my head above water. And by the time I found an attorney, it was expensive enough that it basically pretty near bankrupted me right from the start, because the judge froze all my other assets. I was looking at, tens of thousands. Yeah.
How was the judge able to freeze your assets? I mean, of course they can issue an order, but under what authority did they do that?
Well, it's by judge's discretion. So if you understand, there are a couple of counties in the state of Illinois that are notorious for having corrupt judges collude with GALs to stoke this kind of conflict and to violate your substantive due process rights. I just happened to get the worst one in McLean County, which was only second to probably one in Cook County, as I've talked to my legal team that I've assembled now, and they have looked back on how this unfolded. So this judge had no problem whatsoever of just glaring down over her glasses and telling me that every time I objected, because I was well educated on my case by the time that I first objected to something where she violated a statute. And by the time I objected, she had already decided that her first impression of me was that she didn't like the fact that I was able to call her out on some of these mistakes based on the statutory and the canon and the decorum in the court. And so she took a deep-seated bias against me and had a vendetta. So she was going to do everything that she was allowed to do to violate the law and my rights. So the first thing she did when I said, well, I've got the money in my 401k, just let me take it out of there to get the attorney you keep saying I need to get to represent me, and just let me take it out of there so I can get the attorney.
Why didn't you file a writ after she did that?
Because at that point, I was just starting to realize that I needed to take it upon myself to educate myself and figure out more of the details about what I needed to do. She shortened my window. If I was supposed to have 60 days for an appeal or a writ or any appeal for what she was giving, by the time I figured it out, she had already only given me 10 days or something like that. So if you go back and look at the decisions that she passed down and the orders she made, they were shortening all of the time frames because I was ignorant and didn't know what I didn't know. So they were taking advantage of that already. You're talking about a GAL and her attorney and this judge that are basically three peas in a pod. They are a team.
It's collusion.
It's all collusion. I looked back and I went and looked at the history of who she supposedly they're supposed to draw out of a hat the next available GAL. She doesn't. She specifically picks the same attorney every single time. And so it's a team effort to try to collude and do the backdoor deals. I noticed they kept going back into sidebar or behind the curtain, as we say. And by the time I figured out that they were doing that the first couple of hearings, my fate was already sealed. They had already violated my substantive rights. And I didn't know that I only had so much time. By the time I got to the next continuance for the next hearing, they intentionally continued it and drug it out so that by the time we got to the next hearing, I had already had my deadline expire for trying to appeal.
Why didn't you file a civil RICO against each of them?
Because by the time I learned from my perspective what I could have done, that
I don't think it's too late. I think there's a statute of limitations of civil RICO for like 3 years. I could be wrong. I'm no attorney.
Yeah, those are things that I was frantically trying to figure out, because by the time I figured out my first deadline had passed and that I had gotten buried in this hole, by the time I went to the next attorney who actually helped to the extent that he helped me avoid purge a contempt charge, because the first arrearage for child support came up at $15,000. So the judge said on a Monday at a hearing, I said, I can get the money by Friday. Can you just schedule a hearing on Friday and I'll bring it in? She said, well, let's see, we'll schedule a hearing for Thursday. See, so in a case like that, you already know what you're up against. They're not even trying to hide how they're trying to abuse your rights, you know?
All right, so let's stop right there, because there's a lot in your case, as there is in a lot of others. But this is a teaching podcast, coaching podcast. We're not attorneys. However, based on your experience, we can comment on that and talk about that. So, first of all, did you make sure there's a court reporter at every single hearing?
Yes. Once I saw, like at the second hearing, that a reporter was not there, and I called the judge's secretary and said, why wasn't the reporter there? She said, well, you have to request one within 24 hours of your hearing. And so you're not told that. You're not given like a simple set of basic instructions, even for a family court civil hearing. I was under the impression that for any court, civil or criminal, there was automatically a reporter, because I had always grown up. Maybe it's just the influence of TV and what you see. You always see that person sitting there making the recording, or typing out what's being said. I honestly didn't know until I found out the hard way when I missed having one there. And so I started calling one for every single one, even a status, because a status is different than an evidentiary.
Well, I've seen quite a few status hearings where they've made rulings, and it's important ones too. So you got to have a court reporter at every single one. And if you don't,
yes, they mocked me. She openly mocked me. The judge did, when I called the reporter into the next status hearing. She said she even apologized to the reporter. She said, I'm not sure why we were required to have you here today. So she's rolling her eyes and then darting her eyes over at me.
It doesn't matter. Don't listen. It only matters what you do if you're listening to this. Don't care what the judges do. They're all colluding. Not all of them. They're not all bad, but most of them are. They're all colluding. They're all in the same cases. They all see each other over and over again with different suckers that are all us. And they're all colluding to take money from you. Again, not all, but most. And I've seen it over and over again. I've heard it over and over again. Okay, so everyone knows now you've got to have a transcription at every hearing. If they don't allow you to, you object like mad and just say, look, I requested it. It's not here. I don't want to proceed. Now, the judge can proceed, but you're doing so under protest, and it's probably reversible no matter what happens in that case. You've got to say, hey, the judge didn't allow me to do this. Also, if there's a fraud being committed against you, most courts don't allow recording because they don't want to be caught. but if there's a fraud being committed against you, you can absolutely record what's going on in a fraud proceeding. And to me, a fraud proceeding is, I interpret that widely. I'm not commenting on my own case. I'm just commenting on other people's cases that I've seen. You can also live stream the event, and I would recommend live streaming the event if you can, especially with today's Zoom. You should also have witnesses come, especially in this Zoom world, have witnesses come to every single one of your hearings so that they can be a witness and attest to what's going on. It's also a good strategy to recuse a judge, a bad judge that isn't ruling constitutionally or even according to state constitution. So those are some tips. Hope you're writing these things down. So let's continue. So false silver bullets are being thrown at you. The judges believe it, and then you're put into a state of you're guilty no matter what you do, and everything is now against you. Why didn't you file some sort of protective order against her at the same time she filed one against you?
That was, again, part of the process where I couldn't get up to speed in time. I couldn't get the time in the legal library to research and educate myself fast enough to get the motions and the pleadings down at the time that I needed to in the order I needed to. The other factor was, even when I did try to object and make a filing, the judge was disqualifying my filing by simply saying that under her judicial discretion, she was not accepting the language I put in there. I had a petition for rule to show cause that showed, for example, that she had committed custodial interference by keeping my two oldest, right? Because that's simple to go in and show with specific circumstances, dates, places, witnesses, all that. She shot it down because of the legal language I was using, just because she didn't approve of the legal language. So she allowed me to rewrite it and replete it. But how do I know? Because she's not taking the time in court. I don't know exactly how she wants me to rewrite it. You know, it's like a teacher giving you back a paper in literature or in your English class and saying, rewrite this essay and use the words I wanted you to use. Now go. You see, so there's where you're stuck. No matter what I would have done, even if I was educated enough and knew, she could strike it down by simply saying, the way you wrote it is not accepted in my court. The judicial discretion rules all. So she can do as little as saying it doesn't meet my written standard, or as much as I'm in a pissy mood today and I don't want to be here. And so you're going to lose everything today in my eyes.
Yeah. Well, and that happens, all the more importance to have object. Everyone's going to make sure they object to these things, know your objections, depending on your state. And you put that on the record, and that is an interlocutor. So you could absolutely file an appeal, an interlocutory, which just means that it's got to be heard right away. Whereas a writ, yeah, they can decide to hear it, maybe not, and it's kind of a placeholder for your final appeal, which could take forever if the judge decides to drag it out and never give you a final order. But in something like that, you could do an interlocutory and automatically have it appealed. And had you put the objections on the record and they were relevant, then that could have been overturned and remitted back to the trial court. Now, why did you recuse the judge? Why did you do that?
By the time I was able to scramble and actually hire my first attorney there, Mark, part of the problem was that very first attorney I hired, his intent and his mission was not to, as this is often the case, his mission and his goal was not to represent my best interests. He looked at my financial affidavit and he saw 6 figures, a huge pot of gold sitting in my 401k. And that first attorney in that firm found the ways that they needed to drag it out, get the billable hours racked up as soon as possible, but they weren't addressing my questions. I was asking the very questions you were asking. How come I can't do this? How come I can't do that? Well, first get these interrogatories done first, because we got to get those in, and then make sure you do this and that. By the time I was done doing the basic, just getting them up to speed, I was out $8,000 and they billed me an additional $4 after I told them stop at 8 no matter what, and we need to talk about what's been accomplished at 8. So they weren't my attorney. It was my attorney that was causing me more harm than good. He should have, and they should have, been the ones that were jumping on those writs and those appeals immediately. They did not.
They don't know how to do them. They don't know how to do them. You have to get another appeal attorney to do them. You're best as a pro per to learn them yourself. They're not that difficult.
Yeah. And I found that out, though, too late, because by the time I was going on and finding this attorney, I was part of a corporate structure where we were given an employee assistance program. And they said, if you need an attorney for a desperate legal situation, here's the top 10 that are in your county where you work. So I just went down the list and until I got to the first one that was closest to the top. They were supposed to be reputable. They were not. So you can't depend on the rankings that you get when you're told these are the best attorneys for your case. So if I didn't know how to say it in the exact words for this is what I need, this is still who they gave me, and they gave me the utmost confidence. When you're just grasping, trying to get somebody as quick as possible, you're desperate. You don't have the time. You sometimes don't have the time logistically or even mentally. You just don't have it to where you can get on top of this and get ahead of it. And before you know it, it's too late.
Yeah, and that's the key is you got to watch out for these dates, and they're all different depending on what you're filing. They do this intentionally. They obfuscate and they make it extremely difficult for you to challenge them because they want it all to go smoothly and taking your money away from you and sometimes your kids, a lot of times your kids. So you have to be very sharp in this, and you have to study your state. You have to listen to podcasts like this where you hear people like Richard's stories and what happened to him. And that is critical. So your attorney probably doesn't want to recuse the judge because they're working with these judges in and out of the system. They don't want that judge to rule against them. They all tell me this. Well, I'm not going to recuse a judge or try to piss that judge off because in every case I deal with that judge, I'm going to be ruled against. Now, what does that tell you? If an attorney feels that way, imagine a pro per litigant who this judge is never going to see again. They don't care, and they're going to rule because they have too much discretion to rule against you. So the only way to stop that is to box these judges in, which we'll talk about in a minute. But I want to continue on with Richard's story. So the silver bolts are filed. You get this scarlet letter, this bullshit scarlet letter. What happens after that?
Well, you are at the mercy of all of the demands that are written into the order of protection, which the GAL, since he was colluding with the judge, actually attacked one on top of the general order of protection. So I couldn't talk to any of my children at the time, my 4 children at the time the first order was written. And then what the GAL did was, when he came in and he was supposed to be doing his basic job, interviewing all of my kids and finding out from them what they needed to find out for his investigation, he never interviewed my son because I found out later that my son was ready to give him information that proved that my ex was coercively controlling and brainwashing and poisoning their minds. I found out later that my ex, when I would bring my kids back from my non-custodial visits, she was basically interrogating them. She'd sit them down in the dining room and she would go through a question and answer period and demand to know where I was, who I spoke with, how much money I spent, everything she could possibly coerce out of them to get answers. So he didn't do that. And so what he did do was, once he knew that I had the order of protection and he knew that I was handcuffed financially because of the freezing of my assets, he also piled on top of that if I ever were to get an opportunity to get my parenting time reestablished, he wrote into the order that I had to first go get counseling, mandatory counseling for cognitive behavioral therapy. And he demanded that I start with supervised visits.
Right. Fuck them and their supervised visits, by the way. Who the fuck are they? Some of them tell you how to parent too. Don't get me started. Go ahead.
Yeah. So that is insulting enough in and of itself. So even when I stood up and made a statement in court saying, this is hereby what I am declaring as the reasons why I'm not doing supervised visits, I gave it to him basically straight and square. I don't need to be supervised because I'm not a visitor. This is where I'd done some research and I had caught up with my case and all of the facts and everything I was allowed to say. And so I said, I'm not in prison, and I've never been at a finding of unfitness as a parent. So since you've never been able to tell me I'm unfit or that I'm not qualified to parent my children, I don't need supervised visits. I'm not going to go into supervised visits and be required to pay the fee that you're not telling me I'm going to have to pay for a supervised visit. And so therefore, I'm going to put that aside. I will go to your cognitive behavioral therapy because I already have a counselor and a therapist who can do it or can refer me to somebody else and do it for basically nothing, because it was a pay as you can type of thing. So I went to I could endure the mandatory supervised or cognitive behavioral therapy. Guess what my therapist said? You aren't the one that needs this. Your vindictive ex needs it, not you. And so I checked that box, got my report, went back to the court and gave it to the GAL. And I said, look forward to you giving this to the judge to show I've checked all my boxes. And he refused to give that report to the judge. He sat on that and concealed it and didn't even bring it up when it was the status hearing to hear about what was going on with my counseling and my mandatory.
Did you file a judicial notice with that letter?
I filed a judicial notice and I filed an ARDC complaint, which is basically going to the Bar Association.
Yes, good for you.
And saying that this GAL is this corrupt in that I knew the exact statute and reference to his responsibilities and role. I said he never did A, B, C, and D. I cited the paragraph and section. I explained and showed through correspondence and evidence that he never even interviewed my son, and that our correspondence showed that he was obfuscating and that he was deflecting away from my direct questions about his responsibility. So I was showing that he was intentionally trying to handcuff me in my case. So that complaint went to the ARDC in a file folder with material evidence of probably about an inch thick. And so there's a lot of time spent in putting into that too. So I at least got that on file, even though when you send that, you're basically sending it to attorneys to make a judgment on an attorney.
That's true.
So that is an exercise in futility to the nth degree. So I still got the form letter back, and I at least got it on the record that I filed that with all of the relevant information.
Okay, so the next step then is to file a civil lawsuit against the GAL and the opposing attorney. Did you do that?
Those are things that I'm investigating right now because I'm looking at the limits on statute of limitations for that. My current attorney...
If there's a fraud, there's no statute of limitations, I believe. I could be wrong.
Yeah, that's what I've got my current attorney... I didn't find a good attorney until I fled the state of Illinois and relocated to a neighboring state.
Right.
And so when I found an attorney there, I found an attorney in my new state who had license in Illinois. It's amazing how different things go for you in court when that attorney doesn't have to kowtow to the whims and try to kiss the butt of the judge in your case.
So true.
And so now I'm making headway and getting traction and finding out ways that I can then fight back because my attorney doesn't care what the judge thinks about her and her handling of my.
Isn't that amazing?
It's like night and day. So first order of business, get your attorney outside of the county, if possible outside of the state with a license to practice in your state. That's what I'd recommend.
That is a good recommendation, and keep those coming as you've seen mistakes that you made, and you can't be faulted. This is a whole new language and culture you have to learn. It takes time, and that's why people should be listening to this. And my partner Michael Alexander, if you haven't seen his work, my God, that guy's a master. All right, so wow. I mean, your case parallels quite a few cases that are out there. So I'm sorry you've had to go through that. Let's keep moving forward. So at what point did you lose your access to your kids?
The first order of protection was for the plenary order went for a full year after she got the emergency for a certain number of days. I believe a couple of weeks is the standard. Then it went for a full year. What happened at the conclusion of the first year when I had been completely in compliance with everything, I had zero contact with my kids. I didn't break any of their rules, and I was ready to have my parents. Yeah.
Why did you lose your kids for a year? I think you already said that the GAL collaborated with your ex-attorney, and you didn't appeal at that point, right?
No, because I didn't know the proper appeal process and the deadlines.
Proper appeal is an interlocutory, by the way, but keep going.
Yes. Yeah. What she did was, and people need to know this, if you have cell phones and you're the non-custodial parent and they're your cell phones, I had my kids with their 4 cell phones. They were my property. I paid them under my phone contract. What my ex did was she went in and she started to peruse the entirety of my text messages and emails to my children, and she cherry picked and pulled the ones out of there that she could use to make me look like I was doing things that were bad-mouthing her. They could be interpreted as bad-mouthing her, when in reality, the full context of the conversation was I was giving explanation as to why. For example, if she shuts off the calendar and shuts off her phone, I can't reach her to get vital information to tell them why they missed a particular practice time or a social event or anything else that's going on.
Why, Richard, was that allowed in evidence? That's hearsay.
It was allowed. I objected to it as hearsay because I knew all the objections. She overruled and said she was going to let it stand each time that she. I wasn't familiar enough with the civil rules, the evidence of civil rules of procedure for the evidence presentation, but I did know enough to know it was hearsay. So I objected every single time, and she just kept shouting me down and telling me to stop objecting.
All right. So the proper, obviously, interlocutory, she would have lost because that is hearsay. There's no foundation. She could have just made it up. There's no kid there to validate that happened. Total hearsay, yet she was able to get that in. That's a crime, in my opinion. You could probably sue the judge. It might be too late, but not for monetary damages, but definitely in federal court. But let's keep going.
And so I found out the hard way that, and this is an important factor, I knew the statute because I'd done the research. If you own the phones and your children have them and they're with the custodial parent instead of you, if that custodial parent goes in and peruses that is basically violating your property rights. That's your personal property, that phone. They're not allowed to go in and do that. So when I brought that up in court, the judge pushed back and said, well, Mr. Rindt, I know the law, and they are allowed to confiscate the phone when it's your phone and it's in their household if it's a disciplinary issue. No, in the state of Illinois, the statute is they're only allowed to do that if it's a flip phone. If it's a smartphone, and make sure people understand this, it's a network device. It's considered a computer. So there's a different factor in the statute. You can't go in and peruse email and text from your ex when it's your child's phone you're taking because it's their property. And so it's akin to breaking into the house, burgling the house and taking a laptop and stealing it. So they can't do that. The judge wouldn't accept all of the case precedent I presented. Even in the state of Illinois, I gave case precedent that showed I was exonerated, that all of it was inadmissible. She still accepted it and went ahead and violated my due process rights. Again, at every turn, she did that. And so I was shot down with every piece of evidence and every objection that I made, including the hearsay you talked about, and there was no sworn witness to come in and testify to any of that.
Yeah, I mean, so a couple of points here. She should have been recused long before the trial on that, but you now know that. And there's a specific way to do it. You got to be very careful how you do it and learn from the best before you try it, because there's specific ways that make it a lot easier to get a judge like that recused, especially if they're disobeying the state law, federal law, what have you. The second thing is you didn't, was at that time, did you file your own protective order at the same time she filed her extension?
No, I wasn't aware that I had some of those options because of what I was going through with trying to check. When I finally got my own attorney, I was asking all these questions. Why can't I file that? Why can't I just do it myself? Again, it was that attorney. That attorney was handcuffing me.
Yeah, they want it lopsided so there's more child support and
right
for their coffers under Title 4D.
Yes.
Okay, so you didn't know that you could appeal both protective orders, so a year goes by without seeing your kids. That to me is such a huge civil violation. I hope you could find a way to sue them for that. But okay, so let's go a year. A year goes by, then what happens?
As a year went by and we came to the conclusion where it was going to expire, and I was celebrating the fact I was going to hopefully reunite with my children, I found out that my daughter had actually reached out on social media to my then girlfriend. She wasn't yet my fiance, but she was about to be my fiance. And so completely unbeknownst to me, my daughter had reached out to my fiance, and they had a brief text conversation where all my fiance said was, your dad just wants you to know he loves you, and he didn't want any of this to ever happen. And so when I came back to court for the hearing where it was supposed to be the expiration of the order, to my surprise, out of the blue, I get this text message brought up by her side that is, again, she had gone in and demanded apparently that my daughter show her any text that she was having any contact with me. So she made some kind of threat to my daughter and got this text message, this text exchange, and the court actually made the determination on their own that it was me who influenced my fiance to send the text message. So by guilt by association and through third-party indirect contact, I violated the order.
Oh my God. There's so many things wrong with this. And how is that disturbing anyone's peace anyway? Even if you did, please. I mean, this is such a garbage situation. I can't even tell you, but keep going.
So yeah, all of that, what you just spoke, was running through my head, and my jaw is hitting the floor in court. I'm turning around looking at my fiance. By the way, emphasize getting a witness in court. My fiance always goes and carries a notebook held up right in front of her like she's writing down the next word spoken. That's very important too in terms of court observing and court reporting type of thing. But she was the one who had the knowledge of that. I had absolutely no knowledge of that whatsoever. And so when that was brought up, I tried to basically state my objections respectfully to the court and say, I had absolutely no knowledge of that. And there's no proof even that I had any knowledge of that. And why aren't we having my daughter come in and be a witness, for whatever you're trying to claim? Well, my ex not only was requesting that the order of protection be extended, she requested it be extended for 2 full years, the maximum she could request. So the judge, in her conversation with me, said she was basically doing me a favor by cutting it back to only 1 more year.
Yeah.
Wow. Thank you so much, Judge. You're so kind. So it was extended a whole nother year.
For your kids too.
Yeah. For my ex and by that time, it was my 3 daughters still, because my son had aged out and he was emancipated by then.
Support for this podcast comes from KidsMatter.Charity, a nonprofit dedicated to fighting for kids' rights in difficult divorce situations. Donate at KidsMatter.Charity to help them restore common sense to the family courts.
All right, so he's emancipated. That's fantastic. Let me just stop right here. So at this point, you still don't know about appeals,
right? That my attorneys should have done when I had the attorneys before I had to have them withdraw because I couldn't afford the exorbitant retainers they were requiring me.
I get it, but anyone listening to this, now you got to learn this yourself. You got to learn how to file these appeals. They're very, very, very important, and that one gets heard right away. It's not like you have to wait till the actual divorce is over. Those are interlocutories. Those are really serious things that impact the case going forward. You don't have to wait for a final. The other thing is, at this point, I would be filing, I don't want to say me, but it makes sense, if you're listening to this, to think about either moving this, once you exhaust your appeals in state court, moving this to federal court, because there's so many constitutional rights that have been violated on you, and it's so criminal. The reason why they keep doing this is because they keep getting away with it. Nobody's challenging it. There's only a few people out there that know how to challenge it properly, and that stuff isn't getting out there. The only reason for this podcast is to share people's stories like yours, so they know that there is hope. There are things you can do, and what's happening to you is criminal. And unfortunately, these judges have immunity, and it's very difficult to sue them personally. In fact, you typically can't. There are some ways around that, but in federal court, you can do a lot more with these judges to get them on the right track. But anybody that's doing that to you, what's happening to Richard, you should immediately try to get recused. Learn how to do it properly. If you're in California, there's a different way than Illinois, because this is real serious stuff. You're being withheld from your kids. I would also think about filing a civil action for monetary damages based on your real claim of not being able to see your kids. But wanted to insert that. But Richard, let's keep going. Unfortunately, so you get another year. Then what?
Once I had the extra year tacked on, then it was just a matter of me trying to find every way possible to try and stop this train from running downhill. I started getting a little more desperate. What you do is you start reaching out to those that you kind of left behind in your circle of influence. In my case, my church, those that were closest to me in my church congregation and family. You start questioning why people aren't showing up, or what, I invited everybody that I possibly could to the court hearings. I started reaching out to those and asking them to send a notarized I found out I could have a notarized letter sent to the judge that, for the sake of vouching for me, my character, and my fitness as a father. I had 4 individuals out of about 104 that actually responded and took up that cause and actually went on my behalf and advocated for me and wrote those letters. By the time I got to the hearing where I could present those letters, the judge literally walked into chamber and threw them back at me, and they scattered on the floor. She literally threw them back at me and said that I hadn't followed the procedure, even though her administrative staff told me what her procedure was. So she made up a whole different procedure after she basically said, well, I don't know what they told you, but that's not the procedure I follow. So there's so many things wrong with that kind of response, but I had people trying to do that. I was trying to encourage people to go in person and just explain to the judge exactly what I had then found out about my ex. In fact, that when we were separated and she wanted to take my 3 girls and leave me with my son, that she was actually trying to take them to go stay with somebody who was at the time a suspected child molester and has since then been convicted of being a child molester. So all of these people knew this information and could have just come into the judge and made a sworn statement, spoke on my behalf, and we could have had a whole different trajectory on my case. So I started, reaching out in ways that other people perceived that as me being desperate. They use lots of words that us fathers are all familiar with: disturbed, erratic, irrational, unhinged, crazy, you name it. Anytime you try to reach out in desperation, they label you as being somebody who is becoming unhinged and needs help. And so the harder you try to show
the script.
Yeah. So I reached out. None of that was going on. It wasn't until I was able to go to what's called an intensive therapy for trauma. I finally determined through my counseling, which I stuck with, that my regular counselor said, it's time for you to go get some intense trauma therapy. Otherwise, you're probably going to not survive this because you're not coping well with it. And so by the time I did that,
You just been legally raped.
Yes.
How are you supposed to cope with it?
Yeah.
I'd add them to the list of people I'm suing, but go ahead.
What you're going to most likely find when you're denied contact with your children, and your children were your life for 16 years, when you're denied contact and now you never get to see them for 2, you're going to experience some emotional and psychological torture and terrorism that actually could inflict on you not just post-traumatic stress syndrome. My diagnosis is complex post-traumatic stress syndrome. So you can take the time to Google that up and look at it. But what that means is basically the damage emotionally and the trauma and the pain is refreshed and renewed every morning. You get to respawn and relive that trauma every single morning. And now you have more triggers, because I can just walk out into public and see a little boy run up into his dad's arms and say, "Daddy, Daddy." And that can be enough to just trigger me. That's only one of dozens of them that I have now, because that was my life with my kids.
Yeah. This is legal kidnapping. I think it's illegal kidnapping, and multiple people should be held to account on this. So I hope you move forward with that. So another year goes by. Then what?
When we got to the point where the second year had expired, go to the court for the status hearing, and what happened was at that point, she was having to change attorney. Her original attorney had passed away, so she was changing attorneys, and she's had to change attorneys twice since her first one passed away. So there was a lot more stuff repeated by way of discovery and interrogatories when the new attorneys were coming on, because they had to get up to speed on her side of the case. So I got served with more of that. There was continuance after continuance. I finally filed a modification of child support that was to be considered, because by the time the 2 years are up, I had my oldest son had aged out. So that's obviously a significant change of circumstance, which you need for a petition of modification of child support. I was filing bankruptcy by that point, the expiration of the second one. I was ready to file bankruptcy, and then there were other matters that I had to pick up when I got finally hired and finally was able to hire an attorney. And that only happened after I met my now fiance, and she was able to help provide the financial resources. And so I had to depend heavily on her. And from that point forward, we've had to try to rebuild and get more traction back in my case. So that's been primarily with the modification of child support, because now I've had 3 that have aged out, not just the first one, but 2 more. And there's been enough continuances that it has lasted that period of time where 2 more of my children have aged out before I was even given consideration for the first modification.
So they extended it after the second time, and because she kept switching attorneys, it just stayed status quo?
It wasn't extended after the second time, only in as much as that provision that was in the second order of protection said that even after the second one expires, you don't get parenting time back until you go to cognitive behavioral therapy. Well, I had that, but the GAL never turned in the report. Oh, and by the way, the GAL resigned right after the second one expired. Okay. He resigned because her new attorney is somebody that was hired at his firm. So her replacement attorney it was going to be a conflict of interest. So the GAL had to withdraw from the case. When he withdrew, he took a lot of the evidence that he never presented to the judge that was my compliance for the order. So he never showed the judge that I went to the counseling. He never showed the judge a written report. He never told the judge that he never interviewed my son. So there was even an evidentiary hearing where I brought my son in, and he was going to testify to the fact that the phones were mine and that they were not considered a gift. I tried to recover the phones as my property and made a motion. The court determined, the judge decided unilaterally the phones were a gift. My son knew they weren't a gift. So he came in to testify, and she disallowed his testimony, allowed the other attorney to object all the way through, and he never said anything.
Yeah, of course. Okay. So how long did it take you to get a hearing to hear about visitation?
Let's see, that was only set just a month ago, was when the first one was set, with all the continuances and letting her attorney cut in line with getting up to speed, interrogatories, discovery, and then the constant barrage of continuance.
Discovery of what?
When her newest attorney came on, they allowed that attorney to go to issue marital interrogatories and requests to produce. And so they just pile on more of what I already answered in previous attorneys' interrogatories.
Why didn't you object to that and say asked and answered?
Well, that's what my attorney right now is doing. So when he came in and did that, she's filing that. She filed that and said we're not going to accept those because they've already been asked and answered, objection, relevance, and so on and so forth.
Well, it's fishing expedition. Nothing's happened. Anyway, so question: when did your daughter Kayla turn 18?
February 19th, so a week ago.
So why don't you coordinate with her and your son and produce a parental alienation cause of action in court?
That would be because when your children go through the coercive control and the depth of brainwashing and poisoning their minds and the threats they endured from my ex, when they've gone through that, their minds, they've been in such a toxic environment. There's that shared persecutory delusion, it's called, if you study children and the dynamic of parental alienation. They have been so brainwashed that their first reflex when there's any interaction with you and your children, once you reclaim them and get your parenting time back, their first thing they're going to tell you is, Dad, I don't want to talk about any of the drama. I don't want to talk about anything about Mom and anything of the drama.
Here's the thing. They have parental alienation professionals that I don't know if your daughter at this point would agree to talk to them, but that is one strategy I've seen successful, because if you can label her a parental alienator, that's a restraining order right there, and it flips the case on them.
Yeah, I pursued that completely and persistently. Then, Mark, what I did was I went to the nation's top person who handles abuse allegations in civil and family court. This is an individual who's nationally known, who is a consultant for people that you would know in the regular media, like Dr. Phil, like Steve Harvey, Oprah, those types of people. When you want to get the best, this is the person who comes as an expert witness and a forensic expert witness. So I did that. And so I lined up that individual. But here's the thing, Mark, when I filed bankruptcy, and that was concluded back in July, every next step that you need to take to get the best, to do the best, and to really get you out of the hole costs money, more money. And you can't do that when you're bankrupt. And I'm talking, my entire 401k was siphoned completely dry, 120,000 plus, completely.
I thought it was frozen.
No, they once they had it frozen, once they reopened it, they said the only reason we're going to allow you to open it is so that you go in and pull all of what's left in there after you've paid arrearages for 2 years, because the arrearages pile up when I can't get a job, because you can't get rehired because there's an order of protection on your record. You fail a background check for every next job you want to get. So 175 job applications later, at the pay and the work experience level I was at, turned down and completely rejected because I have an order of protection on my record. It's a spiral. You can't get ahead. You can't get a job to make the money to pay the arrearage, and the arrearage keeps piling up. So the arrearage just keeps piling up. You can't get the job to pay it off. So they take it out of your 401k. They just keep taking it out. And so I finally said, just take the whole thing and pay off my child support. They said, no, we're not going to do that. We're just going to do it in increments as you need to. Well, I'm going to need to because, I can't get the job because of what she's done to me using the court. Well, that's not our problem, Mr. Rindt. We're just here to discuss how much you owe in child support. Here's the calculation. When are you going to pay it? The conversation just goes in a circle. You're completely doomed. You can't ever get out of that cycle because you're just saying, I can't get a job. They say, we don't care. Okay. You just owe the money. Well,
by the way, that is definitely something you should bring up in a civil case that you go against your ex. Is that loss of income? So just FYI. Yeah.
Yeah. And by the way, the reason that I lost my job in the first place is because when she got the first order of protection, I don't know if I mentioned, she sent my closest friend to entrap me. This is part of the plot. She entrapped me by asking me a question that I would naturally respond to out of love for my daughters. So I sent the answer back, and then she used that as third-party illegal contact under an order of protection.
It's also defamation. So I mean, you have a civil case. I don't know about the timing of it, but you should be very careful. If it's an ongoing thing, there is, at least in California, there's not a time limit. But if it's a one-time thing or then there's a time limit. So hopefully you're on top of that.
Yeah. And so the reunion with my daughter came, even though on the very first moment she was emancipated and became an adult in the eyes of the law, from the very first moment that she had opportunity to reconnect with me, she was ready to take it. And she made that clear to my son. So she sent him the message, say, I want to visit with my dad. I want him there on my birthday, the day I turn 18. So that message came to my son. He forwarded it to me. Of course, I was overwhelmed and overjoyed by that news. And so I took that opportunity, made preparations mentally. There were a lot of preparations that went into that. But a week ago today, I was putting my head down on the pillow with the expectation of getting up the next day and reuniting with my daughter on her 18th birthday. So that went very well. All things considered, I had a very productive reunion and reestablishment of relationship there. And so I'm just trying to take that one day at a time. But there's a whole lot of still emotional trauma that you deal with when you're going through that process, because it brings back everything that you feel like you've lost. And there's so much you lose in 3 years of time with your child. I've lost 25% of my daughter's childhoods, all three of my daughters.
Oh, totally. I mean, it's criminal. I don't know what else to say about this, and it's got to be stopped. There's a lot of people working on it. I think, the next 6 months, you'll see a federal class action suit, either in a state or a combination of the worst offending states like Texas and California. So something's happening, but those things take forever. There's a lot of special interest, especially with states, about the money they get from child support, Title 4D. So it's a massive, massive thing. I think the only thing that's going to change it is public opinion. They just don't know about this well enough. There's got to be press that gets involved. It's going to happen, but it's going to take some time. And I know a lot of smart people that are working on it behind the scenes. So, Richard, you've got us caught up to today. I don't think you want to reveal too much about what you're going to do going forward. But if I were in your shoes, there is some case law, federal case law, around custody and making sure that it's, temporary orders are, I don't know. Are you still under temporary orders, or are you on a permanent order?
Well, it's temporary in as much as they've just given the requirement that I fulfill the counseling and the supervised visits. I've already got the counseling checked off. I've given my reasons why I'm not doing supervised visits. I guess it's up to my attorney now to determine how she handles that.
What is the cause? What is the rationale behind supervised visits? What are they saying?
They're saying that because of what they originally accused me of to originate the first order, that I was mentally abusive to the children by talking about the indiscretions of my ex. They already knew that my ex had cheated, and that was why the marriage was dissolving and we were splitting up. And so there was really nothing new that was new information to them that was anything that they had been told. The other things that they were using in the cherry-picked text messages were things that they deemed to be some type of criminal or way to determine me to be unfit. It was nothing more than me just giving them age-appropriate language to explain that their mother, for example, cut off all communication. So part of the reason why they couldn't get to some of these things, or I didn't know about these things in advance, is because she was intentionally trying to make me look like the bad guy by cutting off communication and not filling me in. So when she still got the kids majority of the time, she knows a lot more of the particulars about what's going to happen when it's my night or my weekend. And she would just shut off the Google Calendar or shut off her phone. And so, of course, that's going to be problematic, but that makes me look bad. And that's fine with her, because then when they come back home, she gets to talk about how, how irresponsible I am and how I must not love them because I don't really take care of them the way she does and things like that. So those are all things my son could have testified to, including the interrogating. In that type of toxic environment, there's no way that your kid stands a chance in trying to function in a healthy way. And so you see things like I did, like their grades completely tanked and hit rock bottom, and they struggled with depression and anxiety. And, my daughter was going through all kinds of mental strain.
Right. But why don't you ask for, in California, it's a 730 evaluation where you have a trained psychologist that goes in and determines all this?
When I was able to do that on my own before I hired an attorney there, Mark, I was still bankrupt.
Yeah, I know. I keep saying these things, and I don't mean to sound crass, because they all cost money. They all cost money. I get it.
Oh yeah, if it's worthwhile and it can get you to turn your case around and get you some traction, it's going to cost you a good amount of money, even right from the get-go. Because they basically, it's sad to say, but those people you're talking about, Mark, those same people that can come in and be an advocate for you, they're still assessing your financial situation. They're listening to, what can you afford? Can you afford me? Because if you can, I'm sorry, but I'm going to have to move on to another client. They're looking for the ones that can also afford them. The system is built completely backwards. The people that need the help the most have the least amount of money. And frankly, it's what Gloria Allred said in the Erasing Family documentary and so many others. You get as much justice as you can afford. I'm bankrupt. So all the best things that I could do right now, I can't afford. That's the bottom line. There's no changing that.
Well, yeah, unless you're pro per. You could do it if you're pro per, but then you're treated unfairly. And I want to go into a little diatribe. First of all, no one's helping you, no matter what they say. The Supreme Court has ruled that they're supposed to help you. They're supposed to give you the benefit of the doubt. They're supposed to interpret the documents as if you're a non-attorney, but they don't, and they hold it against you, which I find unconstitutional. But good luck getting that into federal court and then the Supreme Court. That would take forever. So they know they could take advantage of it, so they do. I want to go back to one last thing, child support. So were you forced to sign a child support document and custody document, or was this volunteer? You did it voluntarily?
I was told originally by the GAL that, and the attorney, I mentioned an attorney who came in and allowed me to purge contempt for the first child support arrearage at 15. He actually gave me bad information, and he and the GAL both were basically telling me that I had to sign. I didn't know that a child support agreement that they put in front of you is completely negotiable. I didn't know I didn't have to sign it at all. And so I said, well, is this the best you can do? And they were saying, yes, this is the best we can do, so you'll have to sign this. They were lying to me. I didn't know what I didn't know yet. And so by the time the first one was signed, it was jacked up from $600 a month, which was our agreement at mediation, to $2,000. So that was the best they could do. Well, I found out afterwards it's not. So every subsequent one now that's come, since I have paid off all my child support arrearage with my 401k, each next agreement I say zero. My agreement is zero because I paid it off, and I know I have.
So what would you have done differently when they were telling you this is the best we can do, sign it? What would you have done differently?
I would have done what I started doing with every other order that came from the judge after they went back behind the curtain or took a sidebar without it being on the record. I would say, whatever you just talked about back there that you just brought out to me and wrote into this motion, I'm not signing it. I refused to sign like 3 orders that the judge basically signed my name for me. I said, I'm not signing it.
Unconstitutional.
Yeah, I said, I know my rights. I don't have to sign it. And even though I'm pro se or pro per right here, I'm not signing it. And so I had become aware that they like to do these little sidebars, these little side conversations and backroom talks. Like anyone with half a brain should be able to figure out that there's not good things happening on your behalf back there. They're not even letting you hear it on the record. How could that possibly be fair or unbiased?
It's not. It's definitely a violation of equal protection. I mean, there's so many problems with your case. It's unreal. And I do hope you get a civil lawsuit out of this. Figure it out, because you've got a big case.
Yeah, and I've had talked to a number of people who've given me the same type of encouragement and information. And so I'm doing the best I can. The other thing too, Martha, it's important to note when you talk about trying to learn these things and get up to speed as fast as you can. When I was in the position I was in at my full-time job in a corporate IT environment with all my responsibilities, if you think trying to balance the lives of your 4 children, your work and career, I would need more than just the weekends, because every other weekend is with my kids. I basically got every other weekend, and the court law library is closed on the weekend. And so I would have to find another law library to get to do that. But even with that, during the week, I'm completely spent after my day of work. So I can't get to the law library at the courthouse on work hours because I'm already working. So you have to make some type of alternate arrangement to get into an actual functioning law library where you can ask some questions even from a circulation director or from a librarian, somebody that you can ask where certain things are and all that. And all of that is so much easier handled with an attorney who knows the Westlaw, the Westlaw resources, for example. I had to dig deep into that to find precedent and do all that.
Well, I know. And then you got to know that case law inside and out, and then box the judge in by saying, this is the case law that's ruling, and you make sure that all of that's on the record with the court reporter. And if the judge rules against case law, good luck to him or her. They're going to get reprimanded, and it should be reversed. You never know with the appellate courts, but it should get reversed. And if it doesn't, you go to the Supreme Court of your state. And if that doesn't work, you have a strong federal case. But listen to our other episodes, and we talk about how to do that.
And those are good episodes too, by the way. I've listened to all of them, and they're all right on point. So thanks for that.
Yeah, I mean, any episode with Michael Alexander, and we got another one coming up, is a must listen. Must listen.
Yep. And since I've had the chance to have this opportunity to join you on this podcast, I have taken great interest in doing the background with all your other ones. And I would encourage all listeners who are here in this audience, make sure you find the other ones, because they will most likely be applying to you at some point in your case if they haven't already.
Definitely. So, Richard, I'm going to have you back maybe in 6 months just to get an update and talk through. There's so much to talk through here, but we're at an hour 20. We should probably call it a day. But I want to give you your chance to call out, and you don't have to, the judges, the opposing attorneys, the gal here, and I will make this forever on the internet if you want it. If not, no big deal. I understand why you might not want to, but here's your opportunity.
The players in this clown show that I have endured for the last 4 years start with Judge Amy McFarland, who's in the 11th Circuit Court, Family Court in McLean County, Illinois. She's the ringleader. The ones under her purview, the GAL was Todd Miller at Ogar and Miller Law Firm in Bloomington. The first attorney that my ex used to fire the first silver bullet, her name was Melissa McGrath. She was with Thompson and Weintraub Law Firm, which is now Wood and Kelly Law Firm, which also had hired Gina Wood and Kathleen Kraft, who also were interim attorneys for my ex. Her most recent attorney that withdrew was Gina Wood. Another one that was in that firm was Kyle Korkus. Kyle Korkus actually joined the law firm of the previous GAL, Todd Miller. And then her current attorney, it's Clark Walker. So those are all of the players that all have colluded together in unison to completely destroy my life as a non-custodial parent in McLean County Court in McLean County, Illinois.
Okay. Well, thank you for naming them. If you've come across these characters, we have given you judicial notice, so to speak, that you are probably playing in a rigged game. So just be careful. Reach out to Richard. Is that okay, Richard, if they reach out to you on Facebook or somewhere else? Or do you want to, wish to?
Absolutely. I am available on Facebook, Richard Rindt, last name Rindt. Also on Instagram. I believe I use my shortened name Rick Rindt on Instagram. And then also there are some other social media platforms that you might find. I know I'm on LinkedIn and some of the places where I might otherwise be seeking employment.
All right. Well, really appreciate it. Thanks for joining us today. And Richard, I want to have an update in about 6 months, okay?
Absolutely. Be happy to come back and circle back around and share with you some of the hopefully progress and success I've been able to make.
All right. Thank you.
Thanks again for tuning in. A reminder that we are not attorneys and this is not legal advice. We advise you to do the research yourself or to contact an attorney you trust. There are very few of them. This was Divorce Matters Podcast.